I'm Ben Meiselas from the MeidasTouch network. The estate of Brian Sicknick, the Capitol police officer who was killed after being brutally attacked on January 6th and suffering multiple strokes and then dying the next day. His estate, led by Sandra Garza in her personal capacity as well as a personal representative of the estate, has filed a wrongful death lawsuit against Donald Trump as well as the insurrectionists who were responsible for his death, two individuals who have already been convicted, Julian Cater and George Tanios. This wrongful death lawsuit was filed on January 5th, right before the 2-year statute of limitations on wrongful death cases was set to expire in the District of Columbia. This lawsuit alleges Donald Trump was directly responsible for the death of Officer Sicknick for his conduct. The lawsuit is 47 pages detailing all of Donald Trump's conduct before and during the January 6th insurrection. Let me read a portion of this lawsuit right now. The lawsuit begins by saying, "The peaceful transfer of power is a sacrament of American democracy. Defendant Donald Trump, together with other co-conspirators, defiled that orderly transition through a campaign of lies and incendiary rhetoric which led to the ransacking of the United States Capitol as part of an insurrectionist effort on January 6, 2021 by defendants Julian Cater and George Tanios and many others. The attack on the United States Capitol cost U.S. Capitol officer Brian Sicknick, hereinafter Officer Sicknick, who was bravely defending the cradle of American democracy, his life." Now focus on this portion right here, because in this wrongful death lawsuit filed by the estate of Officer Sicknick, they allege in paragraph 2, although it is beyond question Donald Trump lost the 2020 presidential election, he still remains unwilling to accept defeat. He lied to his followers by, among other things, telling them that the certification of Joe Biden's election was a coup and that their country was being stolen from them. He filed dozens of frivolous lawsuits, all of which substantively failed, and he tried to intimidate state officials, none of whom caved to the pressure. Now, that is very important too. That is all of the types of conduct that Special Counsel Jack Smith is investigating in the criminal investigations against Donald Trump that is underway. The lawsuit goes on to say, out of options and out of time, defendant Trump finally called his supporters to Washington, D.C. on the day Congress met to certify President-elect Biden's win, telling them to stop the steal and that the day, quote, will be wild. Tens of thousands of his supporters came to the district in response, including defendants Cater and Tanios. Some, including defendants Cater and Tanios, planned violence at the U.S. Capitol in advance. Some were stirred to violence by defendant Trump, by Trump's words that day. Paragraph 3, defendant Trump implored the crowd to, quote, fight like hell and walk down Pennsylvania Avenue to the Capitol. According to an analysis of cell phone location data, approximately 40% of the rally attendees did just that. Here's the line: as a direct and foreseeable consequence of defendant Trump's false and incendiary allegations of fraud and theft, and in direct response to defendant Trump's express calls for violence at the rally, a violent mob attacked the U.S. Capitol. Many participants in the attack have since revealed they were acting on what they believed to be defendant Trump's direct orders in service of their country. The lawsuit, the wrongful death lawsuit, goes on to cite other evidence from the January 6th committee as well, and is seeking damages for the loss of Officer Sicknick's life. Now, Donald Trump has responded to this lawsuit, attacking Brian Sicknick's estate, saying that the lawsuit is utterly frivolous and without merit. We should also reflect on the fact that there have been lawsuits filed by other Capitol police officers and members of Congress under the Ku Klux Klan Act, a 19th century statute that has been applied to this context for Donald Trump's disruption and conspiracy by force and violence and extortion of official proceedings, again, resulting in damages and injury. Those cases were all consolidated before a Washington, D.C. federal judge, Judge Amit Mehta. I should also point out that the Sicknick estate lawsuit was also brought in Washington, D.C. That's why the statute of limitations would have expired on probably January 7th, but to be safe, you would file it on January 5th. The attack was on the 6th. The death occurred on the 7th, but you want to file it at least on the 5th to be safe so you don't miss the statute of limitations there. And it was filed just with a few days or a day or two before the statute would have expired. But in the case that was consolidated and working its way up to the D.C. Circuit Court of Appeals and actually reached the D.C. Circuit Court of Appeals, that case was before Judge Amit Mehta. It was filed by members of Congress, Donald Trump, and Capitol Police officers. Donald Trump asserted immunity, that he was engaged in the course and scope of his official duties, and that he was carrying out his presidential responsibilities on January 6th. Amit Mehta, the federal judge, ruled, quote, "The president's actions here do not relate to his duties of faithfully executing the laws, conducting foreign affairs, or commanding the armed forces, or managing the executive branch." Mehta went on to say, quote, "They entirely concern his efforts to remain in office for a second term. These are unofficial acts, so the separation of powers concerns that justify the president's broad immunity are not present here." That was then appealed to the Court of Appeals in the D.C. Circuit Court of Appeals, which heard oral argument about a month or so ago on the issue of immunity. The appeals panel that heard this includes a Clinton appointee, an Obama appointee, and a Trump appointee. They were considering that earlier ruling that I mentioned for Judge Amit Mehta. Back on December 20th of 2022, the Court of Appeals panel actually asked the Department of Justice to submit a brief by mid-January on their perspective about whether the conduct was within the course and scope of Donald Trump's presidential duties. It's actually a big decision that the Department of Justice is going to make. I think an easy one here for them to make regarding the January 6th insurrection. But seeing how they respond when they do respond in mid-January to that request, it's what's called an amicus brief, which also stands for Friends of the Court brief. And that is what the D.C. Circuit Court of Appeals in that case asked the Department of Justice to respond to. What is their position going to be here? Because look, the Department of Justice in many ways is an executive branch department, and so its conduct is usually to support the executive branch's powers and push the limits of executive branch powers. I could tell you that Bill Barr would clearly have said it was within the course and scope and that there would be absolute immunity in these situations. Here, I don't think that's what the Garland Department of Justice will do, but we will see that. So why am I even talking about these Amit Mehta cases? Well, because the rulings there and the decision on immunity and whether Donald Trump does or doesn't have immunity, civil immunity, for his conduct on January 6th would have a major impact on the lawsuit that is brought by the Sicknick estate. In fact, it will likely be dispositive on it. If the Court of Appeals, ultimately it will likely go to the United States Supreme Court, if ultimately they find that Donald Trump is immune for his conduct that day, then the Sicknick case will be dismissed, as well as all of the other cases against Donald Trump would be dismissed. And there's a whole line of cases there that are being weighed. There is a case involving Nixon from the early 1980s where this absolute immunity concept was explained, where someone who worked as a Defense Department official, sued President Nixon. The lawsuit was actually after the Nixon presidency, but sued Nixon for unlawful termination. And what the Supreme Court said is, even if the termination was unlawful, the fact that hiring and firing is a presidential duty because of the powers vested in the executive branch, the Supreme Court, and they said the Constitution generally, would recognize a president's immunity in those situations. The other case was the Clinton-Paula Jones case, which included conduct which predated Clinton becoming the president. And there the Supreme Court said if it predates the presidency, a president's not immune from that conduct. But what hasn't been really explored in the law, what if someone during their presidency engages in conduct which can clearly be construed as the opposite of upholding their constitutional duties on that day? It happened during the presidency, so under Nixon, that would normally be a dismissal versus Jones, Clinton case, which predates or is not outside of the presidency. But here, where the conduct is so egregious and at odds with carrying out the constitutional responsibilities, that is the issue that the Circuit Court of Appeal, the D.C. Circuit Court of Appeals, is weighing. Ultimately, the Supreme Court is weighing, and that will affect the Sicknick lawsuit, be dispositive on the Sicknick lawsuit. When I say dispositive, meaning it will either dismiss the case if absolute immunity is held to exist, or the case can proceed if absolute immunity does not exist. But a big deal, Donald Trump being sued for wrongful death by Officer Sicknick, and Trump's response is to attack the estate of Officer Sicknick for wrongful death. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button. We are on our way to 1 million subscribers thanks to your incredible support. And in addition, check us out at patreon.com/MeidasTouch. We've got great content you can only get on our Patreon site, but most importantly, help grow this independent media platform. Until next time, I'm Ben Meiselas.
Our blue wall stopped the red wave and election deniers got denied election. That's why we're celebrating with the new Democracy Prevails team. We've got lots of work to do, but we should all be proud that when democracy was tested, democracy prevailed. You've earned this. Don't wait. Get yours right now at store.meidastouch.com. That's store.meidastouch.com.